Family lawyers like me are often guilty of saying things like document, 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 and make sure you have a written record of everything that's gone down. But I always hear from moms how they've dutifully documented everything, and at the end of the day, the judge didn't listen to it. And here's what I have to say about that. It is impossible to get all of the facts that you have from your lived experiences with your child's father into court. We have 30 minutes, an hour, 2 hours to present our case, and half of that time belongs to the other attorney. If there's a guardian ad litem or a child advocate involved, they may even get a third of that time. So your time is even further reduced. What the attorney's trying to do is to gather the right details that help present a coherent narrative of what's going on in your case. And now that doesn't mean that everything that you've documented is going to be helpful to advance that theory, but it is going to help the attorney figure out what that theory should be. So the more information you have, the better informed your attorney is, and the better able we're going to be able to create an argument that's going to persuade a court. The attorneys were practicing in these courts, we're in front of these judges, we know opposing counsel and where they're going to go, and sometimes being able to have access to as much of that information as possible is really going to help inform a narrative that creates a story that gives us what we need to share in front of the court. And I know it's asking a lot. I know that in a lot of cases, moms are documenting themselves to death, but this work really is important and it does make a difference.